And the High Court in Nairobi has ruled that the mandatory minimum sentence in the Sexual Offences Act is unconstitutional. Justice George Odunga ruled that the court should exercise its discretion while sentencing sexual offenders and not impose the minimum sentence. Emily Chebet now reports.
High Court Judge Justice George Odunga has ruled that the court should exercise its discretion while sentencing sexual offenders and not impose the minimum sentence. Odunga made the ruling in a case filed by 6 convicts serving offences under the Sexual Offences Acts. The 6 petitioners, Philip Muweke Maingi, Nathan Haemba Makoha, Peter Thanga Kago, Simon Nganga Thengi, Mwangi Mudhui and Joseph Kamau Wakaba, moved to the High Court, arguing that the mandatory minimum sentences are unjust and unfair, adding that the discretion of the judges and magistrates has been taken away. The 6 argued that the Sexual Offences Act ought to be amended so that judges and magistrates can be given the discretion to decide on the appropriate punishment with regard to the unique circumstances of each case that is before them. Justice Odunga in his ruling said the courts are at liberty to impose sentences prescribed as long as the same are not deemed to be mandatory minimum prescribed sentences. He, however, directed that those who were convicted of sexual offences and whose sentences were passed on the basis that trial courts had no discretion but to impose the said mandatory minimum sentences are at liberty to petition the High Court for orders of resentencing in appropriate cases. Emily Chebet, Citizen TV.